Hello and welcome to Afternoon Tea with Karen. Today we're going to have a look at this religious educational institutions and anti-discrimination laws. It's a paper that came out in January 23. The one that's in Parliament at the moment isn't available to the public. So, contents, blocker, colour. I, the Honourable Mark Dreyfus, KCMP, Attorney General of Australia, having regard to the government's commitment to amend the Sex Discrimination Act of 1984 and other federal anti discrimination laws as necessary, including the Fair Work Act of 2009, to ensure that an educational institutional conducted in accordance with doctrines, tenets, beliefs, or teachings of particular religion or creed must do all those things. So we can amend the Sex Discrimination Act of 1984 and other federal anti discrimination laws as necessary, including the Fair Work Act of 2009. Do, 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 do. There's a thing. I've got a time limit, so um, point three there. Last sentence. However, these laws currently provide broad exemptions for religious educational institutions, including early childhood education centres, schools, colleges, and universities. On point eight. Right, this is the group they used for their changing these laws. It was more than 80 individuals. It was targeted, so conducted targeted consultations. And among them were past students, school principals, teachers, parents, educational administrators, religious leaders, members of human rights commissions, lawyers, unions, and academics. Consultees have included members of the LGBT plus community, including the LGBT plus people of faith, Aboriginal and Torres Strait Islander people, and people from all cultural and linguistic diverse backgrounds. A list of those you can find on their website. Not many people and a targeted audience. So, eight. No, point 12. Adopts a framework provided by international human rights laws to seek legislative solutions that would maximise the enjoyment of all relevant rights by all persons. International human rights laws. Just want to point something out on the Commissioner for Human Rights website. Sorry, I'm wobbling around. Sex Discrimination Commissioner Anna Cody said our federal laws must not allow discrimination against students or teachers at any schools on the basis of their sex, sexuality, or gender identity. And I encourage the government to amend the Sex Discrimination Act accordingly. It should be informal work. Anyway, I'm making a submission. This has already happened because it was in 2003. Principles they're going to use. Um, Point four, the Alice Springs Educational Declaration. Wanted to highlight that, I'm a highlighter, but uh, refers later in the document to the difference between state and um, anyway, other laws, and that's one. So principle five. Do, 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 do. More Human Rights Commissioner, UN stuff. Oh, that's the thing I was pointing out. 22. Some treaties impose duties on Australia to take positive measures, like things. This one freaked me out. Uh, Absolutely freaked me out. I did not know this existed in the world. Right. Under the Convention on Elimination of All Forms of Discrimination Against Women, Australia is required to take appropriate measures to eliminate any stereotype concept of the roles of men and women at all levels and in all forms of education, including the revision of textbooks and school programs and the adaptation of teaching methods. Limitations. There's the references if you want to look that one up, where that came from. Managing the rights of managing the intersection of rights, Commonwealth and state and territory laws. Another thing with that Aboriginal one I said earlier. Yeah, that's uh that's down here. So state and territory anti-discrimination law. Up here, constitutional law. That's probably where this Giggle versus Tickle thing, or Tickle versus Giggle thing will end up. Because constitutional law trumps all the things. That's why yes, people want to get in and fiddle with it probably too. So they're anyway fiddling with stuff, other stuff in this document. Do. Other laws and workplace. What does it say? These duties impose some limits on how employees can behave, both inside and outside the workplace, depending on the nature of the role of the employer. Schools are also subject to specific curriculum and accreditation requirements that they must meet in order to be able to operate. Anyway, those things. Pause and read. In the Constitution, what is it? Section 116. Discrimination on the basis of religion. Anyway, there's some charts. Okay, these reforms in relation to students. But like I said, it's amending the Sex Discrimination Act. That's the biggest red flag, that a red light, like panic. Anyway, that yep. Examples. Reforms in relation to staff. Proposition. Yeah. So they're going to put, yeah. Do you mean like someone else fiddled with the the Sex Discrimination Act in 2013? And this fellow worked for that government during that time. Mm. So a trans person can't work in a Catholic church because that's sorry, Catholic school, because that's self ideology, and that's like a deadly sin. Like there's so many reasons that can't happen. But the point is that the government's fiddling with the Sex Discrimination Act. Right, and here it would be reasonable and proportionate for a school to preference an applicant for the position of religious educational teacher who is willing to teach the school's particular beliefs around sexuality, so long as the teacher was permitted to objectively discuss the existence of alternative views about other lifestyles, relationships, or sexualities, manners appropriate to the context. So, do. Yeah, there's nothing I want to point out there. Like I said, and it's up to 9 minutes. He gets we're up to page 29. So this is then what they propose. Technical consultation proposals. So this is what they propose. The first one is subsection of the Sex Discrimination Act of 1984 should be repealed. Whatever that section is. I'm not going to go look it up. I haven't got time. Subsections 38. The point is they're fiddling with it. And 1 and 2 of the Sex Discrimination Act of 1984 should be repealed. The next proposal is The Sex Discrimination Act of 1984 should be amended to specify the exemption of for religious bodies in S37 1D does not apply to educational institutions. The Sex Discrimination Act of 1984 should be amended to specify the exemption for religious bodies in S23 3B does not apply to accommodation provided by an educational institution. Number 5, the Work Act should be amended to specify the exemptions for religious bodies. SS 1532B 195. Get what I'm saying? But amend the Fair Work Act. And yes, proposal number 6, back to the Sex Discrimination Act, should be amended to extend anti-discrimination protections, prohibit discrimination, blah, blah, blah. So, yeah, they're going in and fiddling with federal stuff and other stuff. Right, what are we up to? Point 8, the Fair Work Act should be amended so that these things happen. Stuff. More proposals. The Australian government should ensure any future legislation to prohibit discrimination on the basis of religious beliefs or activity contain exemptions in relation to employment and engagement of contract workers that allow an educational institution conducted in accordance with the doctrine, tenets, beliefs, or techniques of a particular religion or creed to do that. Do. The Australian Human Rights Commission Act of 1986 should be amended so the religious educational institutions subject to the Act. What are we up to now? Number 12. The Australian Human Rights Commission should review the Commission's guidelines for temporary exemptions under the Sex Discrimination Act of 1984 in light of legislative changes proposed. Number 13, the Australian Human Rights Commission. See, she's got skin in the game. In consultation with the Attorney General's Department, should develop detailed guidance to assist educational institutions, administrators to understand how to comply with Sex Discrimination Act of 1984 and the anti-discrimination provisions in the Fair Work Act of 2009, and for the public to understand the relevant protections. This point here, 104, a wide range of stakeholders have raised concerns around the difficulty of understanding, blah, blah, blah. You saw their stakeholders, like a bunch of 80 people. Number 14, following implementation of proposals 1 to 11, the Australian government should consider and consult further reforms to simplify and strengthen Commonwealth anti-discrimination law by addressing inconsistencies arising from reform proposed in this inquiry. And they can do those. And there's their acknowledgements. And that's pretty much the end. You can look those things up, slow them down. You can go look this document up yourself. It's not very hard to find, but it's important to look at it and to know it's out there because this is how they roll. Yes. All right, we're nearly at the end. Do, 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 do. Cautionality. Queensland. Yeah, they just had a homeschooling battle. Okay. Do. Consistencies with overseas practice. So those are worth looking at. European Union framework law implemented across European countries, including Ireland, England. Also consistent with positions in New Zealand law. Uh, um, Subject to more limited exemptions in relation to sex. Oh, there's that colour again. There you go. Ta-da! Yeah, so ta-da! Wasn't that fun? Yeah, that's 15 minutes. See you later. Bye.